Good afternoon, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to get on today and talk about money and finance. But before we get started today, go ahead and feel free to comment. Say something, let me know what's on your mind in regards to money and legal tender and gold clause and all that. We're going to hang out and let a few people join up and have a little discussion first before I go into this reading these codes and stuff. So let's get on with it. What do you got to say? What's on your mind about the money and finance? What's your thinking of legal tender versus money and currency and debt and debt obligations? What's going on? I'm on my phone and this thing tells me I can invite people. And if you're on your phone, it should say something on the bottom. It should have like a profile and then a square with another profile in it. That's your invite or request to join the video. If anybody wants to join, feel free. Otherwise, that's the major point of everybody's problem today is what every issue extends from, whether it be child custody case or child support or traffic tickets. Anything that you're doing with the courts has to do with money, period. It's a bankruptcy court, it's a probate court, it's a tax court, and every last bit of it has to do with this thing called money. So yes, Joshua Rogers says, ab initio is my word for the day. Is that related to money too? It most certainly is, because before anything can have any value, no matter what you call it, you have to go to the beginning and find out what constitutes you, what art, as in Articles of Confederation, what art you use to express the events and occurrences in your life and how they affect yourself, how they prove or disprove whether you are dependent or not dependent. Because independent would be the same as with dependent, and therefore not dependent. The only non-commercial court would be that of a court of record under the common law, in which it would be the Seventh Amendment, which most people don't use. And that's only because today's courts are all acting in that personage. There is no real access at the current time. And actually, I guess I shouldn't say that because things are changing so much right now. But there really isn't any access to that Seventh Amendment ability to a trial by jury of your peers for a sum of 20 United States dollars. Everything's done by Federal Reserve notes today. So, with that, let's get on with today's discussion. And we are going to go first And like always, when I get done with this video, I'm going to post my other, the links to my other forums and my PayPal link for anybody who's interested in sending me some love. We're going to call my form of prosperity by use of their medium of exchange. We're going to call it an exchange of love. So for that PayPal link, it's an exchange of love. For anybody that wants to send me some, please feel free. I always appreciate it. I can always use it in the form of Federal Reserve notes to get my ass off the ground in trying to prove how this stuff works to everybody. Most of you guys are familiar that I quit the commercial system about 4 years ago, and I'm currently gearing up to get back into it. And so today we're going to hopefully help others comprehend my starting point in discerning the differences between the values of everything. And so today you see before you a note I've made on legal tender, and it comes from the primary basis for counterclaims. They're making complaints under a claim of Federal Reserve notes, and legal tender is the primary basis for counterclaims, which is that all commercial instruments such as promissory notes. I want people to pay attention here. They started out such as promissory notes, and every obligation under Title 18 of the United States note is actually a promissory note, because they have no way of actually paying it today, so they can only promise to pay it in the future. A silver certificate is a promise to pay in the future. It is a certificate certifying. That is not the actual silver. They cannot pay you in silver. They can only pay you in a silver certificate. They can only pay you in fractional notes, treasury notes, gold certificates. These are all just certificates or coupons of some kind, or stamps, some kind of signature under an act of Congress, period. So let's start out. The term obligation or other security of the United States includes all bonds, certificates of indebtedness. A promissory note is a certificate of indebtedness. A silver certificate is a certificate of indebtedness of the silver they still owe you. It is national bank currency, not your currency. Your currency is of substance. It is a national bank currency, still a promise to pay, because they are not paying you in substance. Federal Reserve notes. Federal Reserve Bank notes. Your certificate of live birth is a certificate of indebtedness because it is a bank note. Look in the fine print around the border that says American Banknote Company or Midwest Banknote Company. It is the company that printed off said bank note. And it is given by the Federal Reserve. That is where they get the authority. Any bank, branch bank, or United States Bank, any national bank, is getting its authority from the Federal Reserve, and they have the authority to have banknotes printed up for any bank through a banknote company. Coupons. It doesn't say store coupons. It just says coupons. Notice your store coupons will oftentimes say redeemable at so much tenths of a cent per coupon. It has some kind of substantive value. United States notes, treasury notes, gold certificates, silver certificates, fractional notes, certificates of deposit, bills, checks, or drafts for money. What is a draft for money? The very first draft for any kind of, quote, money, an exchange, a medium of exchange, for now, for the future, was an IOU. An IOU, again, is a promissory note. In simplicity, it is just an IOU. Everything is an IOU, drawn by or upon authorized officers of the United States. Drawn by means they can draw it, or somebody else can draw it upon. An authorized officer. The certificate of live birth. Pay attention, people. The certificate of live birth is a certificate of indebtedness. It is a draft for money drawn by an authorized officer of the United States to perfect that title as holder of that instrument. Once you get it and authenticate it, both state and federal level, you place that in a private trust. You establish that it's placed in a private trust. Off of that private trust, you write your own certificate of indebtedness called a certificate of receivership, under which you assign them trustee of the receivership of the value noted as full faith and credit of the United States. You have now perfected the title as the grantee, noting that the United States is the trustee and the person under which all of these statutes applies to is the beneficiary under the 14th Amendment, because it was issued under any act of Congress. Any act of Congress. Act is capitalized, of Congress. The specific Congress they are speaking to is the 11th Amendment. Notice it says stamps and other representations of value. The certificate of live birth under full faith and credit has that value as represented by the words on that certificate. And like I said, you issue them a certificate of indebtedness of your own by proving the representation known as the certificate of live birth, authenticated under full faith and credit. You are now holding them in receivership of the entitled person which they created as trustee of that person, and you are the holder of the instrument that entitles that person to the benefit of their trusteeship, of which you grant them. It clarifies what the actual value is, regardless of legal tender, checks, coupons, United States notes, Federal Reserve Bank notes, Federal Reserve notes, or any other certificates of indebtedness. You now have the full claim as a counterclaim to their certificate of indebtedness known as the certificate of live birth. because it's a promissory note. It's a credit agreement now that you give them a certificate of receivership, because now the credit is placed in the correct position. You are the grantee, they are the trustee, and the person is the beneficiary. We will see this. This will be explained. Nigel Ponder has a question here. It says, can I use negotiable instruments to purchase or take possession of gold? Is a Federal Reserve note a negotiable instrument? It most certainly is. Go to a garage sale and see if they have an item marked for 5 Federal Reserve notes and negotiate it down to 4, 3, or whatever you have in your pocket. It is negotiable. It is an event to take possession. That is what is negotiable. It is the event. So take that money, those Federal Reserve notes, and go down to the pawn shop and buy up every bit of 99.99% gold. 99.9 or 99.99% silver. Buy it up. You now have substantive value through the event. And nobody can disclaim it, period. And checks. The primary basis for counterclaims is that all commercial instruments such as promissory notes, credit agreements, bills of exchange, and checks are defined as legal tender or money by the statutes. Are you defining that as legal tender, or are they? It is defined by the statutes that they wrote. You have to redefine it. You have to define it as full faith and credit. The actual value of the authentication of the person identified as the beneficiary. Now you identify the trustee through receivership. That's your definition. They are clarifying the legal tender or money by the statutes. Legal tender under the Uniform Commercial Code, Section 1-204, number 24. And here we have an official comment. We're going to look at this 1-201. The referenced official comment notes that the definition of money is not limited to legal tender. Therefore, limited is legal tender. Legal tender is limited of itself and is included in the term money. Money expands beyond legal tender to those other things I said, which are promissory notes. Today, you can give legal tender of gold in exchange for Federal Reserve notes, promissory notes determined as money. Just like I explained, you can go to a pawn shop and the man behind the counter will give you legal tender of gold or silver for your money. He prefers Federal Reserve notes because of his cognitive dissonance, but as we see, we can also offer him a bond, a certificate of indebtedness. Equal rights among the law, people. If they can do it, you can do it. We can give them national bank currency. or Federal Reserve notes or Federal Reserve bank notes. We can technically give them a certificate of live birth from the Secretary of State. Now, if we purchase it for $20 from the 20 Federal Reserve notes from the Secretary of State, and we then turn around and offer it for a $15 piece of jewelry, that is not a wise exchange. However, if we go into that pawn shop and we offer it as legal tender under full faith and credit, as so stamped and authenticated, and that man behind the counter does not accept it, he is in dishonor due to his cognitive dissonance. He is in dishonor for not accepting what the United States is obligated to accept, and a certificate of indebtedness, a bond, a national bank currency, a Federal Reserve bank note that you offer him as acceptance for his legal tender, his lawful exchange. He is now in dishonor. So let's continue on. Is not limited to legal tender under the UCC. UCC is international law, people. International law. The test adopted is that of sanction of government. Again, it's written into their statutes because it's a test adopted by the sanction of government. The UCC is written into your state statutes. Your state statutes are international law, bound by contract under federal acquisition regulations, because they use Federal Reserve notes. They use promissory notes for the common, general, public use of all trade. Whether by authorization before issue or adoption afterward, which recognizes the circulating medium as a part of the official currency. Federal Reserve notes are a fractional note. It is partial. It is a part of the actual value. That is an issue before the sanction of government that is authorized through statutes. That is known as legal tender. And it is a medium that we can circulate as a part of the official currency of that government, not the corporation. The government. The narrow view that money is limited to legal tender is rejected. This speaks of, and this is no longer in the quote, this is the author's comment, this is my comment. I'm telling you people, this speaks of species of money. See the coffee bean case, where the guy spoke of this literally and paid, made the medium of exchange in a commodity known as coffee beans at the rate of $1 per coffee bean for what they were offering as a fine, fee, or penalty in that exchange, which was $1,418.75. He told them, here is 1,419 coffee beans. Keep the quarter coffee bean as a tip. His tip was, don't bring me to your insane courts again for any kind of payment, because this is what you're going to get. In light of the holding of Guarantee Trust Company versus Henwood, another very good case, a federal U.S. Court of Appeals ruled that Title 31 U.S.C. 518, as of October 27, 1977, legal tender is for discharge of debt, or legal tender for discharge of debt is no longer required. In order to discharge a debt, we no longer have to give up gold or silver. They cannot require us a substance. They cannot require us even the substance of our own body. This is what tells us they have no authority whatsoever to put any living being behind any confinement of jail, bars, imprisonment, nothing. This is referring to debtor's prison. This is because legal tender, the substance of gold and silver, is not in circulation at par with promise to pay credit. Every one of their instruments is a promise to pay with credit of the legal tender, the substance that is supposed to backing it, because it is partaking